Okay, very good morning. Let us start our today's lecture on advanced system security and digital forensics. So, all of you are requested to kindly write your details in the chat box, your number, name, and the roll number. And we'll start with the lecture on advanced system security and digital forensics. So, in the previous lecture before Diwali, we were speaking about and we have seen the various types of law, various types of what you can say. We have spoken on protecting the security of the computers. In that, we were speaking about the intellectual property. So we have discussed about the patents, copyrights, trademarks, and now we are going to go further, and we have also seen trade secrets. And today we would be going further and we would be seeing about what is an information and the law. So let us start with the same. Right? So now, when I speak about the information and the law, we'll see how the information and how the law plays a vital role. So let me just turn on the PowerPoint slide and we can continue. Yeah. So let us start with the information and the law. So now, to tell you what is an information and the law, so as we all know that the source code, the object code, and even the look and feel of a computer screen are recognizable. Electronic commerce, electronic publishing, electronic voting, electronic banking are all the new challenges that we have. So if you see, everything is now there on an internet. We make use of it. Maybe in electronic commerce, that is e-commerce, maybe in electronic publishing, maybe electronic voting, or even maybe electronic banking. So here we are going to see some of the new requirements and what needs to be done for that. This is what we are going to have a look on, right? So let us see first the information and the law. Now to tell you how information and the law is. So if you can see in the information and law, we have shown that information as an object and information is valuable. Now why I'm saying information is valuable because information gives everything nowadays. So I always say information is valuable. Let me just give an example to make it very clear. Now the shopkeeper, for example, uses to stock items in the store. So when we speak about an example of a shopkeeper, what he does, he makes use of stock items in the store. Maybe buttons, automobiles, or maybe if it's selling a sugar. So this is a kind of a selling a packet of sugar. So the buyers are customers. Now, whenever the items are sold to a customer, the shopkeeper, what he do, the shopkeeper stock of that item is reduced by one, and the customer pay for it, and he's having the item now. So whenever any customer comes to any shopkeeper, the shopkeeper sells one item, and then one item gets reduced, right? And then it depends on the customer. Sometimes the customer also resells the item to someone else for more or less the customer originally paid. Other kind of shops provided services that could be identified as things or items. For example, a haircut by a barber. If you go to a barber, he does a haircut. Or maybe if you go to a doctor or a dentist, and you opt for service such as root canal, right? So, and also maybe a kind of a service, maybe a kind of defense by a court hearing for by a lawyer. So some services has a price for it. For example, if you go to a barber for a haircut, you have to pay a price for it, right? If you pay something, then only he's going to do a haircut, right? Maybe 50 rupees, 100 rupees, or whatever it is. So some services had a set price for doing for getting the service, right? So it depends again. Although one provider might charge more than the other for that service, so somebody might charge 50 rupees for a haircut, and somebody might charge 100 rupees for a haircut. But then again, all such services you have to pay for it, right? Similarly, even a shopkeeper. When I say the shopkeeper, maybe a hairstylist, dentist, or a lawyer. I have taken three examples. So everyone has their own time. For instance, the price of a haircut is another related to the hairstylist time. So how much time does it take? So depending on that, the amount is being calculated. So hairstylist will charge you based on how much he charged for. So based on how much he has given a time to you. Similarly, similarly, if you go to a lawyer, so lawyer is going to charge you based on the amount that he has given a service to you. Even a lawyer or even an accountant is charged by the hour of service, in which there is no any item, but then they are giving their time. Right? If you go to a lawyer, lawyer is not going to give you something in exchange, but then he is going to charge based on how much time he has contributed of himself. So, for example, if it is a dentist, the dentist is willing to sell a certain amount of time, reserving the rest of the day for other activities. So, similarly, everyone has charges for its own requirements. But then today, there is also a third category of sale, which is called as an information. As you all know, nobody even argued against the proposition that information is valuable. Now, how information is valuable, I will tell you a simple example. You all will agree. Now, students normally are tempted to pay others for answers during examination. So, if you have certain examinations, and if you want to have a notes of someone, or if you have want to have notes of somebody, then you are even ready to pay for it, right? At some point of time, you might pay for it also, right? So depending on that, information is valuable. If somebody tells you that they might have some certain questions in mind, and you want the notes of a particular institution or maybe particular classes also, what you're going to do, you're going to pay others for the answers during examination. And even if you see, there are many major business do pay for the credit reports. So if they want to know what is the credit report, they charge you. So you have a CIBIL score, and if you want to know your CIBIL score, even businesses pay for the credit report. They also pay for getting the client list. So probably there is a company who just want to know that who just wanted to know their target visitors or the target users. So they will be charging for the client list. Especially even if there's a recruitment side, if they want to recruit someone, then they will go to Naukri.com and they're going to pay for the database to the Naukri.com to get the list of the clients to whom they can ask for recruitment. So there are several ways for which they are be charging. So information is also valuable, and as I said, information is also chargeable, and students are tempted to pay others for answers during examination, and business pay for credit reports, client list, and marketing advice. Right? So this is the first point. Second point is we are saying that information is not depletable. So if you can see the first point, information as an object is not depletable or may be used repeatedly. It means information can be sold again and again without depleting the stock or diminishing quality. For example, a credit bureau can sell the same credit report of an individual to unlimited number of requesting clients. So that is possible. So same information can be used repeatedly. Second, information can be replicated. It means the buyer can resell and deprive the original seller of sales. It means the value of information is what the buyer will pay the seller. But after having bought the information, the buyer can then become a seller and potentially deprive the original seller of further sales. Because information is not depletable, buyer can enjoy or use the information, can also sell it many times, perhaps even making profit. Third one, information has a minimal marginal cost. What do I mean by minimal marginal cost? Marginal cost of an item is the cost to produce another item one after having produced some already. So if I say if a newspaper that is sold only one copy on a particular day, then how much would be the cost? Obviously, the cost would be very high, very expensive, because it would have to cover all the expenses, maybe the salary of the employees, maybe the benefits of all the writers, editors, the production staff, as well as the share of the cost of all equipment for its production. These are fixed costs needed to produce the first copy. With this module, the cost of the second and subsequent copy is very minute, representing basically just the copy of a paper and ink to print them. If you are making multiple copies, then the charge can be minimum. Then if you are thinking of just having a single copy, we charge you more. So then with this model, the cost of the second copy and probably the subsequent copy is very minute, representing basically just the copy of the paper and the ink to print, because the rest all the other costs are covered. Fortunately, newspapers have very large press run and daily sales, so the fixed costs are spread evenly across a large number of copies that get printed. More importantly, publishers have a reasonable idea of how many copies will sell, so that they can adjust their budget to make a profit at the expected sales volume and extra sales simply by increasing the profit. Okay. Also, newspaper budget by the month or the quarter of the year, so the price of a single issue does not fluctuate based on the number of copies sold of yesterday's edition. But then in theory, a purchaser of a copy of a newspaper could print and sell other copies of that copy, although doing so would violate the copyright. But then this is how it's going to earn the value. Okay. So as I said, if it's printing the second copy of the multiple copy, then the cost of producing additional information is minimal. Next point, if you can see, the value of information is time dependent. Now, when I say the value of information is time dependent, so for example, if you knew for certain that what is the trading price of a share of an Infosys stock would be next week, then information would be extremely valuable because you can then make an enormous profit for the stock market. So if you know, probably most of the stock market and most of the shares get fluctuated up and down in the share market based on the news. So if you come to know, if you have some information that next week something is going to happen with an Infosys, so similarly you can purchase or you can sell and you can make a profit. So in this case, information has the value, right? So of course that price cannot be known today, but suppose you knew that Infosys was certain to announce something next week that will cause the price to rise or fall, and that information is almost as valuable as knowing the exact price, and it could be known in advance, right? So thus the value of information but depending on when you know it. So when you know it also has the value of information. Second, when we're speaking about the information is often transferred intangibly. It means it is difficult to claim information as faulty if the copy is accurate, whereas underlying information is incorrect or useless. So at that point of time, you can also say that often it can be transferred intangibly. So these are some of the information that is related to information. So the way we have seen the information is important. So we have classified them into multiple levels and we have tried to understand about the information and the law. Clear? Okay, Satya, thank you. Now, since we have gone further and understood about the information and the law, let us see what can be legal issues that can come when we speak about an information. So, to explain this, what can be the legal issue? Let me just go back and ask you. If you remember, we have seen a concept of trade secret before Diwali. In that, we have seen a trade secret has the value as long as it remains a secret. So, for example, I've given an example that the Coca-Cola company cannot expect to retain trade secret protection for its formula after it sells the formula. If tomorrow Coca-Cola company decides to sell the formula that it uses to make the Coca-Cola brand or they make the Coca-Cola soft drink, then it cannot be, then there is no trade secret assigned because now that is revealed. Also, if the trade secret is not secure, if somebody else can derive or conclude it. And we have also seen other forms of protection which is offered by the copyrights and patents. As we have seen, neither this applies perfectly to computer hardware or software, and they apply even less well to information. So the pace of change in the legal system is very slow, helping to ensure that the changes that do occur are fair and well considered. So let me just look at several examples of situations in which the information needs are about to place a very significant demand in the legal system. The first one is the information commerce. So when I think of the information commerce, what do I mean? Information is unlike most other goods traded, even though it has a value and is basis of some form of commerce, the market for information is still young. And so far, the legal community have experienced few problems. Several key issues must be resolved. For example, we have seen that software piracy involves copying information without offering adequate payment to those who deserve to be paid. So we have seen that when we speak about the piracy involves copying multiple information, and in that it is being there without offering any adequate payment to those who are deserving to be paid. But then several approaches have been tried to ensure that the software developer or even the publisher receives the compensation for use of maybe the software, maybe for copying the protection, freeware, and even controlling the distribution. But then none of the approach that seems very ideal because even that is not possible. And so a legal remedy will often be needed instead of or in addition to the technological one. So we have technology, but at the same time, we will require some legal remedy to be done for protecting the information. Second, you can see is an electronic publishing. Now, if you see, I have written that when we speak, first one is the information commerce. In that we have seen how can you protect the software developer and the publishers from piracy. How you can stop anyone from stopping the piracy, because that is being compensation should be received either by the software developer or the publisher. But then with piracy, obviously Others are making a profit of it. So there should be some legal issues relating to the information. Second is on electronic publishing. So how do you protect the news organization and encyclopedia in the web for being target for copyright? So if you can see, there are many newspaper and magazines. They post a version of their content on the internet as they do it, right? So apart from doing it on TV, there are many news organizations that they do it. They make a digital copy and they circulate on the website. Now, how can you protect such information in the web from being target for copyright? Because that information is leaked and now we cannot opt for a copyright. So we should expect that some news and information will eventually be published and distributed exclusively on the internet. Now here again the publisher has a problem ensuring that it receives the fair compensation for the work because it is the publisher who has actually gained the knowledge or the information. So this technical problem must be supported again by a legal structure to enforce their use. So that is again the second type. Third legal issues that arise is the protecting data in the database. Now when we say how we can protect the database in the database, now when we speak about protecting data in a database, because database are a particular form of software that has a lot of problems for legal interpretation. Because when we go to the court have difficulty deciding what protection laws to be applied to the database. So how can anyone determine that a set of data that has came from a particular database? How can you know who the owner is? How anyone can claim that the information belongs to him? Who even owns the data in the database is not known, even it is public data. So even if there is a public data such as name and the address of the client, now who is the owner of it? You have an information, but who can be the owner of it? So again, for that you require a legal issue. So these are some of the reasons why you have the legal issues related to information. Now, to protect such information, we have three different laws that we are going to see. That is criminal and civil law, tort law, and the contract law. So we are going to see that. So, as we have seen in the previous slide, that currently the current laws are inadequate for protecting the information itself and for protecting the electronically based form of commerce. So, how can we protect the information legally? So, because again we have seen that the copyright, patent, and trade secret that we have discussed is not able to solve all the issues that are there on the information. So, because of that, we have for protecting the information, we have criminal and civil law, tort law, and contract law, which we are going to understand in the further slide. Okay. Now, let us start with the first one, that is criminal and civil law. So, in the criminal and civil law, you can see there is something I have written as statutes. So, this is some new terminology that you might be understanding as statutes. So, what are the statutes? Statutes are the law that state explicitly that certain actions are illegal, right? So they are the laws that state that certain actions are illegal, and violation of a statute will reveal, or violation of a statute will result in a criminal trial. So in a civil case, an individual, organization, or a company or a group claims that it has been harmed. The goal of the civil case is restitution, right? So, for example, to make the victim whole again by repairing the harm. So, if somebody has done harm, then there is a repairing work done to protect the harm. So, that comes under the criminal and civil law. I'll give an example. What do I mean by that? Now, suppose there is a Fred. I'm just taking a random name. Suppose there is a Fred who kills John. Now, Fred has killed the John. Now, because Fred has broken a law against murder, he has done a murder, the government will prosecute Fred in criminal court for having broken the law and upsetting the order of society. Right? Now, suppose John's wife, Maria, right? Now, the Maria, who is the wife of John, she might be a witness at the criminal trial, hoping to see that Fred should be put into prison. But she also will like to see, she'll also like to sue him in civil court for wrongful death. It means he has done very wrong with her husband John, and Fred has done something wrong. So even she can even seek payment to support her surviving child. So she can again claim in the criminal and civil law that it was the only person, John was the only person who was actually earning at his house. But now he is no more. It is now Fred's responsibility to give the money or give the compensation so that she can able to support her surviving child. And that is there in a part of a criminal and civil law, where if you violate, then the goal of a civil case that somebody should restitute. It means to make the victim whole again by repairing the harm. Now, repairing the harm is not possible. You cannot make John get a life once again, but then at least you can somehow make sure that even the Maria does not suffer. So that comes in the criminal and civil law. Clear? Okay, fine. So let us see about the next law, which is called as the tort law. Now, the tort law, when you're speaking, the tort law is a law of tort which is based on the idea that people are liable for consequence of their action, whether intentional or accidental, if they cause harm to another person or entity. So that is what the tort law is. The tort law says that people are liable for any consequence of their actions. Yeah. So I was saying people are liable for the consequence of their action. So if they do something wrong, they are consequent for the action. So even if the person does it maybe intentionally, or even if the person does it accidentally, if they provide any harm to any other person, they are liable for action. So that comes under the tort law. It means example is a fraud. So fraud is a common example of a tort law in which basically one person lies to another by causing an harm. And if any person does intentionally or accidentally harm to another person, then he is liable for actions. Right? So the concept of this area of law is to provide compensation on wrong done to a person and provide relief from the wrongful act of others, usually by awarding monetary damage as compensation. The only answer to this is that if somebody breaks this law, which is called as a tort law, then under tort law, if something is wrong done intentionally or harm is being done to a person, then the compensation should be given and provide relief for any wrongful act that is done by awarding any monetary damage as compensation. Okay. Now let us see the third law, which is called as a contract law. So what is a contract law? A third form of protection for any computer object is a contract. A contract is nothing but an agreement that is there between the two parties. So when we say there is a contract, it means there is an agreement between two parties. So contract may involve three things: an offer, an acceptance, and a consideration. So one party offers something, like for example, I will write this computer program for you for this much amount of money. So this can be a contract. So if there is a contract between the two parties, let's say I will write this computer program for you for this much amount of money. Now the second party can either accept the offer and reject the offer, right? So if you say I'll charge 5,000 rupees for writing a small piece of code in Java, if your client is accepted, then obviously he'll accept the offer. Otherwise, he'll reject it, or he will make a counter offer that no, 5,000 is too much for writing such small piece of code. I will be giving you 3,000. So he can make a counter offer, or he can simply ignore it. So it can be everything. But then a contract involves three things: an offer, an acceptance, and a consideration. Right? So the basic idea is that two parties should exchange the thing or the value, such as the time traded for money or technical knowledge for marketing skills. For example, you can also have a contract saying that I will just wash your car if you feed me a dinner. An example, right? A written contract can involve hundred of pages of terms and conditions qualifying the offer and the consideration. So information here is often exchanged under contract. Contracts are ideal for protecting the transfer of information because they can specify any type of condition. So you have the right to use but not modify the information. You can have such kind of a contract that others can use your use a piece of software, but they cannot modify the information. Or you can have a right to use but not resell the information. Or you have a right to view the information but not allow others to view it. So it depends on you what kind of contract you want to allow. So depending on that, you can have a contract in which two parties agree and the contract can be made depending on the requirement. Okay. So since we have seen various kind of laws that are there for protecting the information, let us go further and see what are the rights of an employee and an employers. Now there are certain rights of any employees and there are certain rights of any employers. So what are the rights of employees and what are the rights of employers? We are going to see here. Now let me explain this. As we all know that the employers normally hire employees to generate idea and make products. So if any company is recruiting you, the main intention is that you generate the ideas on behalf of company and you make the product. The protection offered by copyrights, patent, and trade secret appeals to employers because it applies to the ideas and products. But then, however, the issue of who owns the idea and product is a complex. So ownership is a computer security concern because it relates to this right of an employer to protect the secrecy and integrity of work produced by the employer. So I'll give an example to make it more clear. Now there is an employer who is hiring someone on an employee, right? So employers wants that whatever things that the employees make it. So he wants that this need to be protect secrecy and integrity. The employer is not supposed to review. So let me give an example to make it much more clear. So what can be the rights of employers and what can be the rights of an employee if there is a computer products are concerned. So let me give an example. Let me take an example. I just take a name as Lakshmi. Suppose Lakshmi works for a computer software company. Just assume there is a girl named Lakshmi. She is working for a computer software company. Now, as a part of her job, she develops a program to manage the windows for a computer screen display. So she is writing a normal program that will manage the windows for a computer display. Now the program belongs to company because company has paid Lakshmi to write the program. So she has written the program as a part of the assignment, as the work that is given to her. So Lakshmi then cannot market this program herself. She cannot sell this product, even if she has worked for a non-software related company, but developed her software as a part of her job. She cannot tomorrow sell the same product to someone else. So most employees understand the respect of the responsibility of the employer. So this comes under this comes under the rights of employees and employees. So there can be several questions when the ownership of product is concerned, like who owns the patent? If the employee has made such kind of and if she has made such kind of a product, then who owns the patent? That can be one question. Second can be who owns the copyright, work for hire, licenses, trade secret protection, and employee contract. So we are going to see who can be the ownership of such kind of a products and who has the right, whether the employer or the employee. And answer to all these questions we are going to see in the further slide. But then the only concern is the right, what the employee's right is and what the employee's right is. Clear? So going further slides, we are going to see each one of them in detail. Any doubts so far? Should we go ahead? Yeah. Okay. Thank you, Sajjad. Yeah. So now let us see the answer to this question. Who owns the patent? Okay. Thanks, Sajjad. Yeah. So now the question again comes: who owns the patent? Now the person who owns a work under patent or copyright law is the inventor. So in the example discussed earlier, the owner is the programmer or the employer. But then under patent law, it is important to know who files the patent application. So if an employee lets an employer patent an invention, the employer is have to have the patent, and therefore rights of all the invention goes to the employer. So if an employee is writing anything and he lets an employer patent an invention, then employer is the holder of the patent, and therefore all the rights goes to the patent or the employer. So if the employer lets an employer patent an invention, the employer is having a patent, and therefore all the rights of an invention goes to the employer. The employer also has a right to patent if the employee's job function includes inventing the product. So for example, in a large company, there might be a lot of scientists we hired. So in large company, there is a scientist hired, and scientists are hired for doing research and development. Now, if we do any research and development, and the result of this inventive work now becomes the property of the employer, because employer has hired the scientist, and the scientist has done an invention. That is okay, but then scientist cannot claim because it is the employer who has hired the scientist, and then research and development is a part of the employer. Research and part is the work that is given to a scientist. So then, in this case, the result, whatever is generated of this inventive work, now becomes the property of the employer. Even if an employee patents something, the employer can argue for a right to use the invention if the employer contributed some resources, right? So tomorrow, even if the employee files the patent, the employer has the right that he can argue, he can bring it to the court, and he can say that the invention, the employer can argue that the invention that has been done, it was because the employer contributed some resources, maybe by giving some money, by giving the salary, or by giving the computer time, or by giving the access to the library or the database in developing the invention. So in this case, the ownership goes to the employer, right? The employer has a right to patent if the employee's job function includes inventing a product. Now, second question comes, then who owns the copyright? So, patent का तो समझ में आया, but then who owns the copyright? So again, the owning of copyright is similar to owning a patent. Similar, it is similar way. So the author or the programmer is presumed the owner of the work, and the owner has all the rights to an object. However, there is a special situation known as work for hire, applies to many copyright for developing the software or other product. So what is work for hire? We are going to see probably in the next slide what is the work for hire. But then when we speak about the ownership of who owns the copyright, copyright is again similar to the owning a patent. The author is presumed owner of the patent or the programmer. But then again, a special case arises, which is called as work for hire, that applies for many copyrights for developing the software or the product. So let us see what is the work for hire. Okay. So when we speak about a work for hire, in a work for hire situation, the employer, not the employee, is considered the author of a work, because the relationship between an employee and the employer is considered a work for hire in certain conditions, right? So what can be the work for hire? So for example, if there are certain conditions that are true, then we can say that it comes under the work for hire. So for example, if the employer has any supervisory relationship, it means employer is always there who has a supervisory role, that he has hired someone and somebody is working on behalf of that. Second, the employer has the right to fire an employee. So if tomorrow, if there is something wrong happens with an employee, and the employee is charging something, some ransom amount, then employer has the right to fire the employee. So employer arranges for all the work to be done, and then it becomes that the employer's work. So written contract between the employer and employee states that an employer has hired the employee to do a certain work. So as we have seen that the discussion in the previous case when discussing about the case of a Lakshmi. So Lakshmi develops a program on her job. Her employer will certainly claim a work for hire relationship, and then the employer can now own all the copyrights and should be identified in place of the author for all the copyright notice. So now he is actually one who is having a right for copyright. Okay. Now let us go further. There is one of a license. So an alternative to a work for hire agreement is a licensed software. Now let us see what is the licensed software. Uh, Now in this situation, the programmer develops and retains full ownership of the software. Now if there are certain things which the developer does not want that the employer should get benefited, so the employee can actually have a certain kind of a situation called a license software. So in this situation, the programmer or the developer can retain the full ownership of the software. In return, for a fee, the programmer might grant a company a license to use the program. So a programmer can develop a program and then he can give a license to a company to use the program. The license can be granted for a definite amount of time or an unlimited period of time depending on the programmer's choice. But then license can be granted for a definite amount of time or unlimited period of time for a single copy or maybe an unlimited number of copies to use in either in one machine or to use in many other machines for limited amount of time and unlimited amount of time. So all these questions can be solved with the license. So here, the programmer makes an arrangement that how he wants to give the rights of the program to someone else. So this arrangement is highly advantageous for the programmer point of view because, as you seen in the work for hire arrangement, because the work for hire arrangement was basically advantageous for the employer, because employer was hiring someone, and then it's your invention, it's your thing, and you have developed something. But then tomorrow, it's again the property of the employer and not the employee. But then in the case of a license, you have a choice and you can grant certain rights or you can decide how much ownership you want to give of the software, right? The choice between the work for hire and license is largely dependent on what the two parties will agree to. Clear? Okay. So I hope you have understood the difference between the licenses, work for hire, and what are the protection against what you can check up employee and the employees is concerned. Now going further, let us understand what can be a protection for a trade secret. Now, a trade secret is actually different from either a patent or a copyright in that there is no registered inventor or the author. There is no registration fees or there is no registration office for the trade secret. In the event if a trade secret is revealed, the owner can prosecute the revealer for damages suffered. But first, ownership must be established because only the owner can be harmed. So if somehow some information is revealed, the owner is the one who is going to get harmed. The company owns the trade secret of its business confidential data. As soon as the secret is developed, the company becomes the owner, right? So there are something trade secret. If there is something a part of a trade secret, for example, for a soft drink brand, if they come up with one of the uh, procedure in which how they can make a soft drink, then can be a trade secret or what the ingredients are. It can become a business confidential data. And as soon as the secret is developed about how to get it prepared, the company becomes the owner, right? So in case of a trade secret, a company owns the trade secret of all its business confidential data, right? Now let us speak about the employee contracts. An employment contract often spells out right of ownership, but sometimes the software developer and the possible employer have no contract. Having a contract is desirable both because for the employees and the employers, so that both will understand their own rights and responsibilities. So sometimes the software developer and the employer they never have a contract, but it's always better, as I said, because if you have a contract, then obviously the employer and employees are aware, so that both will understand their rights and responsibilities. Typically, an employment contract specifies that an employee be hired to work as a programmer exclusively for the benefit of a company, right? Then and then only an employee is hired. So in an employment contract, you can have a contract that specifies that the employee be hired to work as a programmer exclusively for the benefit of the company. The company states that this is a work for hire situation. The company claim all rights to any programs developed, including all copyrights and all the rights to market, it only with the employer. So contract may further state that the employee is receiving access to certain trade secrets as a part of the employment, and the employee agrees that he will not reveal any secret to anyone. So that can be a part of the contract. Okay. So now since we have understood about everything, let us go ahead and discuss about redress of for software failure. So whereas the redress for software failure, it means what are the reimbursement for a software failure. Now, when I'm speaking about the reimbursement for software failure, uh, let us understand what is the meaning of that. So, redress for software failure, what should the reimbursement be done for any software failure? So, for example, if there are any software, and what should be done when such software faults are discovered? So, as we know that program development is done by any programmer. So, programmer normally does the program development, which is a human process for designing, for creation, or for testing, which involves a lot of communication and interaction. For this reason, there will always be an error in the software we produce, right? Even if we say it's 100% written correctly, but there are always error in the software because at the end it's a process or design of creation by human beings. So for this reason, there will always be an error in the software that we produce. We sometimes expect perfect consumer products, such as an automobile, right? So, for example, let me just tell you, we do not mind if you go outside and if you order something. Maybe if you ask for a cheese pizza, and in our pizza, if there are not amount of cheese, then it's okay. Similarly, there is a crack on a ceramic tile. But if an instance of a product is not usable, But then if that is not usable, then we expect that the manufacturer to provide some remedy, such as repair or replacement. As I said, if suppose we find there is a crack in a ceramic tile, we have went outside for a shopping of a tile, ceramic tile, and you found that there are a lot of cracks on the tile. What will expect? You will expect that the manufacturer or a shopkeeper should give you an appropriate remedy. Maybe like he might give you a replacement of it, or he might give you the money which you have paid it for it. So you want the replacement. Okay? So in fact, the way in which these people are handling can contribute to the vendor's reputation for quality service. But when we speak about the software, software is very different. When we say that there is some failure in the software, then what needs to be done? So situation is very different, right? So as I said, there are two examples which I have given. For example, if you have gone outside and if you have a cheese pizza, and in that if there is not sufficient cheese in it, what can be the solution for such kind of a failure? Obviously, you can tell the person that to add some more cheese on top of it, so that you can enjoy the taste of a cheese pizza, of a cheese itself. That you can do. If you go and if you find out that if you've taken a tile which was a ceramic, and if you found there are a lot of cracks on it, the solution can be that you can go back to him and you can tell him that there are a lot of cracks on it, and either to replace it or either to give the money back. But then there is a certain different condition when it comes to software. Because an operating system is a great deal more complex than many consumer products and more opportunities for this failure issues. For these reasons, we are going to discuss on it. So we are going to discuss what are the legal issues in selling correct and usable software. What are the moral or ethical issues in producing the correct and usable software? What are the moral or ethical issues in finding the problem, reporting the problem, publicizing or fixing any flaw? So in some way, the legal issues are evolving. Everyone acknowledges that all vendors should produce a good software, which everyone requires. Everyone wants that the software which they purchase should always be an error-free. It should be a good software. But that does not always happen. The more difficulty comes in in the development maintenance. Because what we do when faults are discovered, we have purchased a software, but what if that software is not running tomorrow? So these are certain problems we have when we speak about the redress of software failure. So we'll continue the answer of this probably in the next session. You are requested to join back in the next session. Kindly write your details in the chat box, the UI number, name, and the roll number. We'll join again back in the second session.